To move the motion.
Thank you very much, Ms Vaz, and thank you for that introduction. It's a pleasure to speak here this afternoon under your chairship. That's the right word. Securing this debate has come at an extremely important time. Lasting powers of attorney continue to be granted across the country, and whilst it's clear that the vast majority of attorneys act in the best interests of the donor, there is considerable abuse still amongst the very small minority who don't. Now, since the campaign that I've been involved in to end the abuse of lasting powers of attorney began, I've received hundreds of testimonies from across the country where vulnerable people have had their funds stolen or used for purposes not in the interests of the donor. Most of the focus in this campaign has been on the abilities and implementation of powers by the Office of the Public Guardian. But I think it's important that we look at the root cause of these abuses and why they're able to occur in the first place. The abuse often begins following interactions with banks. Now, there's no getting away from the fact that the digitisation of lasting powers of attorney processes has opened the door to abuse from a very small minority of unscrupulous individuals who've taken advantage of the ease with which an attorney can gain access to a donor's bank accounts. The lack of legislation and duties placed on banks has resulted in an uneven implementation of safeguarding when it comes to lasting powers of attorney. And that's why our campaign has called for the implementation of government-regulated safeguarding procedures for all banks over the way they deal with LPAs and the accounts of donors. Yes, of course, I'll give way.
Madam Chair, first of all, can I commend the Honourable Gentleman for all the hard work that he does in this House. I don't think there's anybody in this House who isn't impressed by his dedication, his interest and commitment, and here's another example. In Northern Ireland, the Enduring Power of Attorney is a legal document that lets you choose someone to make decisions about your property and financial affairs if you lose the mental capacity. Unlike England and Wales, there is no equivalent to the lasting power of attorney for health and welfare in Northern Ireland. Instead, a separate process is available through the Royal Courts of Justice to appoint a controller if no EPA exists. So does the Honourable Gentleman not agree that these processes, both here and back home, must be streamlined and accessible while still ensuring that the safeguards are in place to protect from abuse of power? Thank you.
David Hamilton.
I'm very grateful to the Honourable Member for Strangford. I'm sure it's still Strangford, isn't it? It always has been. For his intervention. And he will see later on in my speech how I intend to address the issue of safeguarding. Because to me, that's one of the most important parts of this process. Let's be clear that the vast majority, as I said in my introduction, of lasting powers of attorney have no difficulty, problems or issues whatsoever. It is the small minority that cause the grief, where people need to be safeguarded from abuse. And that's where we need to concentrate our efforts, I believe. So, I mentioned the government-regulated safeguarding procedures for all banks over the way they deal with LPAs and the accounts of donors. Now, that would include contacting the donor or a GP before an LPA is activated and monitoring spending prior to and after the LPA is activated. I'm afraid, Ms Vaz, that this abuse is absolutely rife in that small minority of cases. And the increases don't scratch the surface, given that most cases are undetected, are not thoroughly investigated, and are not reported as often as they should be. The Office of the Public Guardian's annual report made this clear last year, in that there has been, for example, a 6.5% increase in the number of concerns about abuse raised with the OPG, but a slight decrease in the proportion leading to a full investigation, from 34.5% to 33.9%. Very small, you might agree, but that is a lot of people. And every individual concerned has a family and relatives and friends who are also deeply concerned. 2 weeks ago, I hosted a round table for banks administering lasting powers of attorney alongside UK Finance. They verified that these figures have been seen in their work on vulnerability, with the OPG admitting that approximately 65% of potential financial abuses are being disregarded simply because the donor is deemed to have capacity. But let's be clear, someone may have capacity, but this does not mean to say that they cannot be coerced or financially abused. Yes, of course.
Thank you, Chair. Thank the Honourable Member for giving way. In light of the projection of 1.4 million people that will be living with dementia in the UK in 2040, would the Honourable Member agree with me that we need to make sure that there are sufficient safeguards in place to protect those vulnerable people? Thank you.
I thank the honourable gentleman for his intervention, and of course, with the increase in dementia, in Alzheimer's, projected to rise almost, incrementally, certainly, he's absolutely right. Safeguarding needs to be far, far tighter, and I'll go on to say what I think that would involve. At our meeting, several banks highlighted clear failings within safeguarding procedures and investigations by the Office of the Public Guardian. Given that the OPG will not investigate any case where the donor is deemed to have capacity, that they have no powers to access financial records of attorneys, investigations are, at best, toothless. Then, of course, the banks face a back-and-forth situation with the Office of the Public Guardian, as both urge the other to investigate what they claim to be, and I quote, a civil matter. Banks regularly ask the OPG whether they should act on an account under investigation, but they're told it's up to them as banks to decide whether or not to do so. Now that begs the question, what is the purpose of the OPG and why does it lack the powers to act? Now one example raised with me by one of the banks was where a single individual had tens of LPAs registered to himself, but UK Finance were not aware. So no investigations took place until concerns were raised and a bank conducted a vulnerability check on the donor. By then, of course, it was too late. The individual had already gathered the funds of several people. This case is sadly not an isolated incident. Yes, of course.
I thank the Honourable Member for giving way and also for his dedicated work on this subject. Does the member agree with me that given over 6 million people in the UK hold lasting power of attorney agreements, mandatory safeguarding procedures for all government staff handling LPAs, alongside clear guidance for banks, are essential to protect vulnerable people in communities like mine in Redditch?
Hamilton.
I thank the honourable member for Redditch for his timely intervention, and he's absolutely right, of course. That is what the campaign has been arguing for since it began, because the publicity given to the cases that I raised last November on the floor of the House in my 10-minute rule bill led to a widespread number of cases from up and down the country, often through their own local MPs, coming to my office and saying, can we add to your list of the abuses? Now, those abuses in total don't amount to maybe more than a fraction of a percentage of the total number of LPAs granted. The honourable member said 6 million. I believe it's more like 8 million. But a small percentage of 8 million is still an enormous number of people. I think these issues go much further too. Whistleblowers at the OPG have told me that there's no potential attorney is ever vetted, and that it's extremely easy to walk away with a signed document stating that you're the attorney. Let me repeat that. No potential attorney is ever vetted, and I think that's rather worrying. There's evidence of abusers producing fake religious documents to claim that they're married to people who are decades older than they are and who clearly lack capacity. Technically, this still isn't against the law. So despite it being utterly immoral, there's very little the OPG can do about it. As I've said, hundreds of cases of potential abuse have been highlighted with me since I introduced the Powers of Attorney Bill to Parliament last November. I'd like to raise some more of them now, in addition to the cases I raised in the House last year. Azar Hayat lost his life savings as a donor through the granting of a lasting power of attorney, an alleged investment of £126,000 £100,000 was transferred to his attorney, with most of the funds going directly into the company of which the attorney was the sole director. Mr. Hyatt's funds were then converted into shares in the attorney's name, and he subsequently lost everything in one foul swoop. The same year, the attorney closed the company, leaving with all the funds. And this has left Mr. Hyatt in a position where he's had to seek an order for the sale of his own home in order to survive financially. The OPG took over 4 months to terminate this LPA, and by then, as ever, it was too late. It was only after an intervention from his Member of Parliament that Mr. Hyatt had to seek to recover funds via insolvency, a situation, I'm afraid, which failed, so he didn't recover any of those funds.
Give way.
Yes, indeed.
Thank you. I represent Tiverton and Minehead, and Minehead has a very, very large elderly and deprived population. And I'm just wondering if we as members could help Mr. Hamilton in his best endeavours by encouraging our constituents, particularly if we live in or represent these sort of constituencies, to come forward and talk to us as their MPs so we can pass on their representations to you. Sorry, to Mr. Hamilton, because Mr. Hamilton is doing an excellent job.
Fabian Hamilton.
Very grateful to the Honourable Member for Tiverton and Minehead, and thank her very much for that intervention. And yes, indeed, my office, based in Leeds North East, my constituency, is actually specialising in trying to compile a list of all the cases that have come to us, every one of which is different, but they all have one theme, and that is unscrupulous individuals who've taken advantage of a lasting power of attorney in order to gain the funds of the donor as quickly as possible for their own nefarious purposes. And that indeed is a tragedy and is part of this ongoing trend we see towards the abuse of older people, which we have to stop. And I think we have a duty as parliamentarians to do just that. Another victim, Nicola, wrote to me outlining her family's tragic case. Nicola is not alone when she describes the interaction between banks and prospective attorneys as, and I quote, a tick box exercise. In her case, the bank's representative queried a change to the power of attorney that had occurred a few months earlier. The bank only asked for an affidavit from the solicitor to ensure the capacity of the donor. It was later, however, shown in court evidence that the solicitor had a conflict of interest between the subject and their business manager. At the time of the bank's involvement, the donor had received a diagnosis of Alzheimer's disease, which had been confirmed by a CT scan 9 months earlier. The donor's deteriorating health was clear, with the LPA activated on health grounds being actioned a year earlier. The LPA for finance was invoked following the specialist diagnosis. Now, the donor was isolated, away from her brother, whom she had originally appointed as the attorney to protect her interests. The safeguard of unanimity was removed by the solicitor without advising her brother until months later, when it was far too late. Yes, of course.
The honourable gentleman for giving way, but am I mistaken? I understood that actually one could only execute a power of attorney if you had capacity, and therefore if there had been a diagnosis of Alzheimer's, surely that would not be possible. Am I incorrect?
Hamilton.
No, the Honourable Lady is not incorrect, but before that diagnosis is actually made, the LPA can be executed in advance of any potential diagnosis. If somebody feels they're losing capacity to make financial decisions or decisions about their future health, they can, when they feel that that's starting, they can actually execute the lasting power of attorney to be implemented or to be actioned once, this is my understanding, once the diagnosis is made or once capacity is lost completely or irreversibly. I'm sure the Minister will correct me on this if I'm wrong. Now, the brother was then removed as an attorney 2 months later when he challenged the withholding of the donor's income and the clawing back of historical expenses. He was replaced by the donor's accountant. Nicola told me, and I'm quoting from Nicola now, the donor in this case had a long-standing history with the bank, both in her personal and business capacity. The bank would have been aware of the manager taking over the management of her personal banking affairs going back years. This may have started as a convenience for the donor, but later became a necessity. That partly answers the Honourable Lady's question. This casual arrangement, apparently accepted by the bank, allowed financial abuse to follow. Now, obviously, in that case, the Office of the Public Guardian doesn't have a role. The business, but does in the later parts of the story. The business manager and the accountant both admitted in court that they'd withheld income from the subject from the preceding year and continued to withhold income until the donor's death 7 years later. Nicola has rightly called for banks to have annual face-to-face meetings with their elderly clients in order to establish their ability to manage their affairs on their own without outside influence, alongside any changes to LPA documents and wills within a year of a diagnosis of a cognitive illness like dementia, which should be treated with caution and investigated thoroughly before it is granted. Serious anxiety about this issue exists within the industry too. I've spoken to sources within the Office of the Public Guardian and Trading Standards who've highlighted their concerns regarding the lack of the use of powers and systemic failure to protect people. An officer with over 30 years' experience in trading standards told me that they're seeing the numbers of this type of abuse climb to levels they'd never seen before, but can never prosecute them because of lack of assistance from the OPG. Another example was when the officer had suspicions that a certificate provider was selling LPAs for far more than the usual registration fee. But when evidence started mounting up, the OPG and the Competition and Markets Authority failed to provide crucial information needed to prosecute. So I'd be keen for the Minister to look into what steps are taken to verify that a certificate provider is genuine and is not making profits from their work. Another experienced officer from the Office of the Public Guardian told me of their utter frustration at the processes. They cited a 4-month backlog, which is allowing abuse to continue, and in a lot of cases gives the abuser ample time to move money around in order to escape justice. They told me that when grounds to investigate processes begin, they're not actually acted upon for weeks, with timeframes only set for investigations after this has taken place. OPG staff say that since the introduction of digital applications for LPAs, demand for investigations has increased and suggested that best practice is for the Court of Protection to give consent if the donor has lost capacity and the attorney wants to gift a substantial amount of money. However, this is being applied inconsistently amongst banks, as there are no regulations that ensure they follow it through, and banks are simply taking the attorney's word that a donor has lost capacity. This staff member pointed out to a declining morale at the OPG because of the rise in cases, with little to no safeguarding training, and even expressed a concern over, and I quote, the dehumanisation of the people they deal with. These are some of the most vulnerable people in the country, and some are being coerced or abused, and that's clear. Members of this House have previously looked closely at lasting powers of attorney. In 2004, the Health Select Committee endorsed the recommendations of the Joint Committee on the Draft Mental Incapacity Bill relating to lasting powers of attorney. The Joint Committee recommended clarification of the extent and limitation of an attorney's powers, as well as adequate guidance and training for donors. Further guidance to be provided to warn donors of the potential for conflict, and an additional safeguard should be included in codes of practice as a mechanism by which the Court of Protection or the Public Guardian could monitor the use of LPAs with a view to preventing the abuse and exploitation of an attorney's powers. I think it needed a bit more punctuation there. That an express duty of care should be incorporated into law in respect of attorneys acting under an LPA, in that a greater degree of accountability should be required with specific requirements in the form of a standard code of conduct, which should be included in the codes of practice, and that attorneys should be placed under an obligation to notify both the donor, the bank and the public guardian that the donor lacks capacity or is losing capacity, thereby putting this information on the public record and opening it up to challenge. I'd like to thank the Minister for meeting with me earlier this year, following the introduction of my bill. I know she takes these issues extremely seriously, and I'm pleased to see her in her place today for this debate. I'm also very grateful to the victim survivors of this horrendous financial abuse, who've shared their stories with me. Each story holds similar patterns, but each one has its own victim, who's often coerced and robbed of their life savings and assets. Finally, I'm struck by the commitment of those who've reached out to me. Ending this injustice for other families and vulnerable people is their driving force, and I cannot commend them enough for their selfless and committed campaigning on what is an issue that could impact any single one of us. I look forward to the Minister's comments.